y'all. Are you sitting here now for Rachel? Okay. Just waiting for my ballot.
She doesn't have to be done in 2A.
All the jurors down in 2A were cheering when I let them go. We need the jurors.
Hey, don't fuck up. You do that all the time. No.
You'll see the difference. He's probably out here. He's like, oh, I keep hearing him make complaints. That he's like, good hands. That he's Do you guys work for the state? I don't know about fun Connor, but they want us to be here, we can just drive ourselves.
He has to read a bunch of instructions first, and then what the opening statement is, all that crap and everything.
Driving ourselves without any speech.
It's a good thing that they're getting along already.
Sometimes.
All rise. All right, go on in.
I gotta remember who the alternates are. On the jury. She's an alternate.
All those seats are taken. Everyone can have a seat. Ladies and gentlemen of the jury, at this time, the court's going to give certain warnings and admonitions. It is important that you be fair and attentive throughout the trial. Do not discuss this case among yourselves or with anyone else. Do not permit anyone to discuss it with you or in your presence. Do do not form or express any opinion on the case until it is finally submitted to you. More difficult for you to understand is that you may not discuss this case among yourselves until it is finally submitted to you. You will receive the opening statements, the evidence, the arguments, and the law in that order. It would be unfair to discuss the case among yourselves before you receive everything necessary for your decision. You must explain this rule to your family and friends. When the trial is over, you'll be released from this instruction. At that time, you may discuss the case and your experiences as a juror, but you are not required to do so. Until that moment, you must control your natural desire to discuss the case both here and at home. Do not talk with the attorneys, parties, or witnesses during the trial. Likewise, the participants in the trial must not talk with you. If anyone should attempt to discuss the case with you, report the incident to the court or to the bailiff immediately. You may not investigate or attempt to obtain additional information on this case outside of the courtroom. This would include any research on the internet, in the libraries, in the newspapers, or in any other way. Make any investigation on this case on your own. Do not visit or view any place discussed in this case. And do not use internet maps or Google Earth or any other program or device to search for or to view any place discussed in the testimony. Also, do not research any information about the case, the law, the people involved, including the parties, the witnesses, the lawyers, or the judge by using a computer or smartphone, iPad, or any other device or application that accesses the internet. Or any social media such as Facebook, Twitter, Instagram, MySpace. Do not read any news stories or articles in print or on the internet or in any blog about this case or about anyone involved with it. Listen to any radio or television reports about it or about anyone involved with it, or let anyone tell you anything about any such news reports. If you want, you can have your spouse or friend clip out any stories and set them aside to give you after the trial is over. I assure you that when you have heard all the evidence, you will know more about this case than anyone will learn through any media, and or it will be more accurate. In short, you may not investigate or attempt to obtain additional information on this case outside of the courtroom. It is highly improper for any one of you to attempt to do so. Any violations of these orders may cause a new trial or may require a penalty for disobedience. In the event you experience a personal problem, you may explain the matter to the bailiff or the court reporter. The message will be conveyed to the court. At each recess, I will repeat these warnings, but if I should forget to do so, you should remember them and apply them to your conduct throughout the trial. I'm not going to reread this after every break. If at any time you discover that you cannot hear or understand a witness or lawyer, then please speak up so the problem can be corrected. Before we hear the opening statements of counsel and begin to take evidence, I believe it would be helpful if you were to have some preliminary instructions to follow. To counsel, I will give you further instructions covering additional law which you are to follow in this case. It is the duty of the judge to instruct you in the law, and it is your duty to follow the law, as I will state it to you both now and at the conclusion of the evidence. First, all questions of fact submitted to you. In connection with this duty, you must determine the effect and value of the evidence. You must not be influenced in your decision by sympathy, prejudice, or passion towards any party, witness, or attorney in the case. The attorneys for the parties will of course have active roles in the trial. They will make opening statements to you, question witnesses, and make objections, and finally will argue the case as the last step before you hear my final instructions and commence your deliberations. Remember that attorneys are not witnesses, and since it is your duty to decide the case solely on the evidence which you see or hear in the case, you must not consider as evidence any statement of any attorney made during the trial. There is an exception, and that is if the attorneys agree to any fact. Such agreement, stipulation, or admission of fact will be brought to your attention, and you may then regard such fact as being conclusively proved without the necessity of further evidence on such fact. If a question is asked and an objection to the question is sustained, you will then not hear the answer, and you must not speculate as to what the answer might have been or as to the reason for the objection. If an answer is given to a question and the court then grants a motion to strike the answer, you are to completely disregard such question and answer and not consider them for any purpose. A question in and of itself is not evidence and may be considered by you only as it supplies meaning to the answer. As jurors, you have the sole and exclusive duty to decide the credibility of witnesses who will testify in this case, which simply means that it is you who must decide whether to believe or disbelieve a particular witness. In determining these questions, you will apply the test of truthfulness you apply in your daily lives. These tests include the appearance of each witness on the stand, his or her manner of testifying, the reasonableness of the testimony, the opportunity he or she had to see, hear, and know the things concerning which he or she testified, accuracy of memory, frankness or lack of it, intelligence, interest, and bias, if any, together with all the facts and circumstances surrounding the testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. You are not required to believe the testimony of any witness simply because it was given under oath. You may believe or disbelieve all or any part of the testimony of any witness. You should not decide any issue of fact merely on the basis of the number of witnesses who testify on each side of the issue. Rather, the final test judging the evidence should be the force and the weight of the evidence, regardless of the number of witnesses on each side of an issue. The testimony of one witness believed by you is sufficient to prove any fact. Also, discrepancies in a witness's testimony or between his testimony and that of others, if there are any, does not necessarily mean that you should disbelieve the witness, as people commonly forget facts or recollect them erroneously after the passage of time. You are certainly all aware of the fact that two persons who are witnesses to an incident may often see or hear it differently. In considering discrepancy in a witness's testimony, you should consider whether such discrepancy concerns an important fact or a trivial one. This concludes my preliminary instructions to you, and I hope they will be of some assistance to you in listening to and considering the evidence. Please keep these instructions in mind as you listen to the evidence and statements of counsel. I may give you additional instructions during the trial. When the evidence and closing arguments are concluded, I will give you additional instructions on the law which you are to follow. Members of the jury, I would like at this time to highlight the procedure of the trial. First, each of the attorneys will be given an opportunity to tell you what they expect their evidence will be. This part of the trial is called opening statements. The opening statements are not evidence, but they are a preview of the claims of each party, designed to help you follow the evidence as it is presented. After the opening statements, the state will be permitted to present its evidence. Then the defendant may offer evidence if he desires. If the defense presents evidence, the state may present rebuttal evidence. After the evidence is presented, then each of the attorneys will be given an opportunity to make final arguments to you. Then the court will give you instructions in the law. After that, you will retire to the jury room and deliberate on your verdict. With this understanding, the attorneys will present their opening statements. Again, these statements are not evidence, but are what the attorneys expect the evidence to be. Any opening statements on behalf of the defense? Or state, I'm sorry.
On August 24th, 2023, the defendant, Connor Grubb, chose to fire his gun at Kiya Young, striking her in the chest and killing her and her unborn child. The defendant was a police officer with Blendon Township Police Department at the time of the incident. He was on duty, assisting someone who was locked out of their vehicle in the parking lot of Kroger, located at 5991 South Sunbury Road in Blendon Township, Franklin County, Ohio. Another Blendon Township police officer, Sergeant Eric Moynihan, was also present at the scene. As the officers were in the parking lot, Kiya Young exited the Kroger store and entered her vehicle, which was parked nearby the officers. A Kroger employee also exited the store and told Sergeant Moynihan that Kiya Young had just stolen items from inside of the store. Kiya was still in her vehicle in her parking spot, so Sergeant Moynihan proceeded to knock on the window of her car, telling her to get out of her vehicle and that the employee had just stated that she had stolen something. Kiya Young refused to exit her vehicle. Defendant then walked to the front of Kiya's vehicle and drew his firearm, pointing it at her and commanding her to get out of the fucking car. At that point, Kiya attempted to leave the parking lot. Defendant was standing in front of her vehicle near the driver's side. Kiya actually used her right turn signal and began to slowly move her vehicle forward, turning her steering wheel to the right. As she inched forward, defendant still remained standing in front of the vehicle. Defendant actually first placed his hand on the hood of the vehicle. Defendant then took several steps backwards, moving with the vehicle. Ultimately, defendant was easily able to step back into the side of the vehicle to avoid harm, as the vehicle was going so slowly and turning to the right, away from him. However, as defendant was moving back into the side of the vehicle, his firearm still drawn, he shot his gun through the windshield of Kiya's car. The bullet struck Kiya in the chest and immediately incapacitated her, leaving her vehicle uncontrolled. The vehicle continued moving and came to rest after running into an exterior wall of the Kroger store. Kiya Young died that day, as did the unborn baby girl she was carrying inside of her. Numerous officers responded to the scene as a result of the shooting. Efforts were made to render aid to Kiya, but due to the nature of the gunshot wound, she did not survive, and neither did her baby. There's no question that Kiya stole liquor bottles from inside of the store that day. The evidence is going to show that. The state is not going to dispute that. But the state is here before you because absolutely no one should have been killed for taking the actions that Kiya took that day. And as a result of defendant's unreasonable and unjustified decision to stop Kiya with deadly force, he stands accused of the charges that the judge previously read to you. At the conclusion of all the evidence, there will be no question that the defendant knowingly fired at Kiya Young. There will be no question that as a result, she was struck in the chest and died. There will be no question that her unborn child died as well. So this case ultimately comes down to the question of whether or not defendant's decision to use deadly force was justified. At the end of the trial, you'll receive detailed instructions from the court on the applicable law, but the ultimate question for you to answer is this. At the time defendant chose to use deadly force, did he reasonably believe that Kiya presented an imminent threat of serious physical harm or death to himself or to others? And that question is to be answered from the perspective of an objectively reasonable police officer. And after all the presentation of all the evidence, the state is going to ask you to find that the shooting was not justified because no reasonable officer could have reasonably believed that Kiya Young presented an imminent threat of serious physical harm that day. Defendant drew his firearm and placed himself in front of Kiya's vehicle due to an allegation of shoplifting. And even then, he was still able to step out of harm's way with ease, as she was clearly turning away from him and moving her car so slowly. The evidence shows that she was not running over the officer with her vehicle, and that the shot fired by defendant was utterly unnecessary to defend himself. He was easily able to step aside to avoid harm, and avoiding harm had nothing to do with his decision to discharge his firearm. He wasn't defending his life or anyone else's. He was simply stopping her. During the trial, the evidence will show that a typed statement by defendant was provided to BCI investigators. BCI is the Bureau of Criminal Investigations. It's the investigative agency for the state attorney general's office. The evidence will also show that much of what is described in the statement by the defendant as to the justification for why he fired his weapon and killed Kiya is different from what is depicted in the video of the incident. evidence will also show that after the incident, BCI processed the scene and no firearm was found on Kiya's person or inside of her vehicle. You will also hear from Professor Seth Stoughton, an expert in police tactics and use of force. And you will hear about how defendants' actions were contrary to generally accepted police practices and policies. You'll hear from Dr. Jeremy Bauer, an expert in biomechanics. Dr. Bauer will tell you that based on his analysis of the video evidence, the positioning and movement of defendant at the front corner of Kiya's vehicle is not consistent with the defendant being in imminent danger of death or serious bodily harm. The state is not here to put law enforcement on trial or to condemn police officers in general. The state has profound respect for law enforcement. It is one of the most essential roles in any functioning society, and the state works closely with law enforcement every single day. But no one is above the law either. And on August 24th, 2023, 2 lives were unjustifiably taken by defendant. And that's why the state will ask you to put aside all biases and preconceived notions and follow the evidence to the only logical conclusion. The shooting of Kiya Young and her unborn child was unjustified. Kiya Young posed a threat of serious harm to no one, and no reasonable officer could have reasonably believed that she did. The state will ask you to find defendant guilty of each and every count of which he has been charged, related to the deaths of Kiya Young and her unborn child.
Any opening statements on behalf of the defense?
Thank you, Your Honor. May I have a moment to set up?
You may.
Thank you.
Rachel.
Note did you give?
May I have the evidence cart, Ms. Cook? I did test this out before while we were on break, so hopefully it goes according to plan here. May I proceed?
May?
May it please the court, Mr. Collins, Mr. Grubb, Mr. Glennon, Mr. Brandt, Ms. Claypool. Good morning. Don't let the prosecutor confuse you. This case is not complex. It's really rather quite simple. The essence of this case comes down to one line. One line that won't be given to you by either one of these prosecutors, and one line that won't be given to you by we as the defense. But rather, the essence of this case comes down to something that you will hear from Judge Young himself in the jury instructions. And that is an immediate threat to the officer or others of serious physical harm or death will permit him to respond with deadly force. An immediate threat to the officer or to others of serious physical harm, a broken back, a broken hip, a skull fracture, serious physical harm or death will permit him to respond with deadly force. Now, the jury instructions are what you will be required to follow while you're back there and deliberating. And this concept will be in those jury instructions. Now, neither one of these prosecutors will be able to refute the fact that a 3,500-pound car is capable of causing both serious physical harm, a broken back, a broken hip, a skull fracture, able to dispute that certainly a 3,500-pound car can cause serious physical harm or death. They won't be able to dispute the fact that a 3,500-pound car can be weaponized into a deadly weapon in the matter of split seconds. So why then was Miss Young an immediate threat to the officer or others when she possessed a 3,500-pound deadly weapon with her foot on the trigger, the accelerator? Why was she an immediate threat? Let's talk about it. On August 24th, 2023, you're a police officer. You're working a normal summer afternoon shift. On this day, you were called out to the local Kroger to assist an elderly woman who locked her keys in her car. Parked right next to where you've responded is a car that's backed into a handicapped parking spot. That car has no license plate. It's backed into a handicapped parking spot, and it's got no handicap placard. It's parked in the manner in which somebody may need to get a quick getaway, punch the accelerator, and get out of Dodge. You're no rookie. You know that's suspicious.
A19.
I'll be around West Florida.
Copy. 273.
73.
I take the 29, 3705 Managua, 3705.
A Kroger employee then comes running out of the Kroger. Someone has robbed the store of liquor items. That suspect is ducking into that car with no license plate, no handicap placard, and the one that's parked in a handicapped parking spot, but backed in. Your sergeant, he's been on the job longer than you, immediately goes over to the suspect in that car. He's standing at the driver's side window of the vehicle. The suspect is refusing to comply with his orders. The officer, your sergeant, Sergeant Moynihan, is trying to de-escalate the situation. The suspect, the one accused of the theft, she's in control here. She can stop the problem.
Eliminating much of a loss for a 10.
Out of the car.
Now, you realize your sergeant is telling someone to get out of the car. You realize your sergeant may need help, that this person may be charged additionally with resisting arrest, with obstruction of justice, with obstruction of official business. Not only do you realize that your sergeant might be in danger, but there are at least 4 other people in that Kroger parking lot that you can see as you're approaching. One is a child with a grocery cart, pushing the cart back to the return. Now, as a police officer, you were trained in contact and cover. That when one officer makes contact with a suspect who's already refusing commands, a suspect who very well may be willing to hurt you or kill someone else, that when that officer makes contact, this officer is to cover that sergeant. Where is the only place you can safely cover your sergeant and make sure no other innocent civilians are in the way? of a stationary, parked car. Now you'll notice there are no taillights in that car. That car was not moving. That is the only place to safely cover your sergeant and not put any of the other civilians in harm's way. You stand in the front of the car because a reasonable person would see that an officer, a uniformed officer, is not only to the left of your driver's side, but is also standing in front of the car. You stand in front of that parked stationary vehicle because a reasonable person doesn't then start the car, doesn't drop the car into gear, and doesn't proceed to drive that 3,500-pound deadly weapon into a uniformed police officer. Any other position in that parking lot could have put innocent civilians in harm's way, could have put civilians in a position for crossfire should that suspect have had a gun. But the suspect, Mr. Glennon was right, did not have a gun, but she possessed a 3,500-pound deadly weapon and put her foot on the accelerator. That child returning that shopping cart all the way to the left of the screen, she will be the first one run down if this suspect peels out and tries to make a break. That child needs protecting too, so you stand in front of a stationary parked vehicle. Contact and cover.
Car. Out of the car. Out of the car. Out of the car.
FedEx 7 back in service, 1828.
Your sergeant is to the right. Certainly you can't stand right next to the sergeant and still safely cover him. A Kroger employee is by number 2. And number 3, you can see the top of the elderly woman's head just below that handicap parking sign. The elderly woman who you were just assisting. The other way, here's your view. Again, 4, 5, 6, 7, 8. There are people, innocent civilians, all over this parking lot. Now the suspect is still refusing to de-escalate. She continues to resist lawful orders. She's not free to leave at this point in time. Police are required by law to investigate crimes like these. She needs to be placed under arrest for not only officer safety, but for everyone else's safety in that parking lot. And because you know that because that car has no license plate, if she flees, if she commits another crime in the process, like hitting down that child with a grocery cart, because there's no license plate, you as a police officer have no way to track that car down. Your sergeant is about to break the glass on the window to get the suspect out of the car. She's continuing to resist. She's increasing the danger and becoming more volatile.
Get out of the car. Then get out. No, then get out.
At some point, she starts the car. She drops it into gear. You are trained to know that sometimes suspects in vehicles who who are already resisting arrest, sometimes those suspects want to hurt you. You're trained that sometimes police officers get run down by vehicles. Even a slower moving vehicle can still cause a broken hip, a broken back, a skull fracture, a traumatic brain injury if that car bumps into you at a slow moving pace and you fall and crack your head on the pavement. You know this. Then she pulls the trigger of that 3,500-pound deadly weapon. A quarter of an inch push on that accelerator, and that kid returning the shopping cart may be run down. You may be run down. She's coming at you. Her tires squeal, the sound of a peeling out, the sound of a car that's about to go very fast. You try to move out of the way, but it's too late. Her bumper, her moving bumper, comes into contact with your legs. You try to brace yourself for impact and go up on the hood, but both feet leave the ground. And in 1.665 seconds, faster than someone can snap their fingers 4 times, you have to make the decision to defend yourself. You fire just one shot. Because one shot is all it took to stop that vehicle from sucking your feet under and pancaking you onto the pavement. One shot was all it took to stop that car from running down anybody else in that parking lot.
Get out of the fucking car. Get out of the car. Get out of the fucking car.
In 1.665 seconds, you decide to defend yourself, to stop that 3,500-pound deadly weapon from seriously hurting you, to stop that 3,500-pound deadly weapon from sucking you under the car and pancaking you into the pavement. 500-pound deadly weapon from hitting any of the innocent shoppers in that Kroger parking lot on August 24th, 2023. Now, while this is happening, while this is what you're seeing, this is what your sergeant's seeing. Your sergeant is being drugged by that same car. Your sergeant is seeing you, at least 1 foot being pushed backwards. And at this moment, Connor Grubb has not fired. Your sergeant then sees the second foot leave the ground just before he fires. Connor does not fire until both feet are off the ground, until he is hit by the 3,500-pound deadly weapon and both feet are off the ground. Now the car keeps moving. You run to catch up to the car. Comes to a stop by way of the building. You have to get her out of the car. You break the window to get her out. Her foot is still on the gas when you pull her and retrieve her from the vehicle. You realize at that point that she needs life-saving measures. You remember, you've got chest seals in your car. You sprint to your cruiser to obtain these chest seals. Because the job of a police officer, even though you felt like she just tried to seriously hurt you, like she just tried to seriously hurt other people in the Kroger parking lot, the job of a police officer does not stop. And neither does the job of a Marine. So you go and get that chest seal. You sprint to get it. You sprint back to the suspect. And only then do you realize that not only did she put you at risk, not only did she put all of the other innocent shoppers at risk at Kroger on that day, but that she also put her unborn fetus at risk. The rest of the day, you cooperate with law enforcement. You cooperate with your work. The rest of the day, you're praying that she lives. But she doesn't. You know she shouldn't have done this. But it's still heartbreaking. You know that following the lawful commands of both yourself and your sergeant would have prevented this. But it's still a tragedy. And you know, had she not hit you, had she not run you down with that 3,500-pound deadly weapon, you never would have had to fire just one shot. But it's still sad. That is what the evidence will show. Now, the video I showed, I stopped it at a certain point. And there's a reason for that. And that's because, as the judge will tell you, while you're evaluating the reasonableness of this, you are only to consider what Connor Grubb knew at the time. So everything else that happens after the fact does not come into your analysis for reasonableness. Now, I'm sure you will see the video of the life-saving measures that Blendon Township took on the driver over and over and over again. These prosecutors, they've subpoenaed every single officer with any type of body-worn camera who was on the deceased. So I'm sure you will see it over and over and over again. And that's why Mr. Collins talked to you in voir dire with what he talked to you about. But the judge will tell you, you are only to consider what Connor knew at the time that he was hit by a 3,500-pound deadly weapon. Connor Grubb is a decorated Marine. He has never had to fire his weapon at a civilian in the line of duty before. And on this day, he faced every law enforcement officer's nightmare. Now, the prosecution, Mr. Glennon, just came up here and told you Miss Young was not an immediate threat. Their own witnesses are going to tell you differently. So pay attention when those witnesses take that witness stand and tell you that a moving vehicle at you as a police officer can absolutely be an immediate threat. Their own witnesses will tell you differently. Mr. Glennon just tried to tell you that she wasn't a threat. But she started the car. She dropped it in gear. She hit the gas. And she hit a uniformed police officer with a 3,500-pound deadly weapon. And she drug another. She put innocent people at risk on that day. Now, we are here because Connor had the right to defend himself against a 3,500-pound deadly weapon when he was run down and hit, when he was in danger of having a broken back, a broken hip, a fractured skull, when he was in danger of being sucked under the vehicle and pancaked onto the pavement. Connor Grubb had a right to defend himself, and that's why we are here today. Now, remember the law and the burdens and the fact that the prosecutors have the burden of proof. In every criminal case, it starts with the prosecution. And it is they that must prove to you, beyond a reasonable doubt, every single element of every crime charged, including those mental elements. If they prove their case, then and only then do you get to our burden. And it's a lesser burden than the prosecution's. It is a feather more than 50%. A slight tipping of the scales, more likely than not. That is what the standard is that we have to prove to you that Connor Grubb was allowed to defend himself. So what two things do we have to prove? Number one, that Connor believed he was in fear, that his life or others' lives were in danger of death or serious physical harm. A broken back, a broken hip, a skull fracture. And we have to prove that by a featherweight more. The second prong that we have to prove is that his decision to use deadly force was reasonable through the eyes of a reasonable police officer, not sitting behind that driver's side wheel, but rather standing in Connor's shoes, perceiving what he then perceived. And we have to do that without the benefit of hindsight. So how will we meet our burden of a feather more than 50%? How will we meet that burden? By a preponderance of the evidence. The first prong, that Connor believed his life or others' lives were in danger of serious physical harm or death. Well, Mr. Glennon told you he did comply with BCI. He wrote a statement and he told them everything that he's gonna tell you. He's going to take the stand and tell you that he was terrified of being sucked up under that car and pancaked onto the pavement. He's going to tell you about his concerns for every other person in that parking lot. And that is how we will prove, by a feather more than 50%, that he believed his life was in danger of serious physical harm or death, and he believed that others' lives were in the same boat. The second prong, that his decision to use deadly force was reasonable through the eyes of a reasonable police officer. Again, not sitting behind the wheel of that car, but rather standing in Connor's shoes, perceiving what he then perceived when he was hit and run down by a 3,500-pound deadly weapon. How are we going to do that? Well, you're going to hear from an expert witness. His name is Kevin Davis. Kevin Davis has been in the field of law enforcement for longer than I've been alive. He is a former Ohio Peace Officer Training Academy instructor. He taught cadets here in the state of Ohio. He's a certified force analyst. He wrote the book on use of force investigations. He's a trained police officer from this state, an expert witness in the use of force. Now, the prosecutors are going to call some opinion witnesses also. The first opinion witness that Mr. Glennon mentioned was a man by the name of Seth Stoughton. He was a police officer 20 years ago for maybe 5.5 years in Tallahassee, Florida. He's never been certified to enforce the laws here in the state of Ohio. He's never taught at the Ohio Peace Officer Training Academy. He's never been to the Ohio Peace Officer Training Academy to sit for classes or audit those classes. So keep that in the back of your mind, because he's going to give you some opinions about a case that happens here with a police officer who used lethal force here in the state of Ohio. Keep that in the back of your mind as you judge his credibility. The second opinion witness that the prosecutors are going to call is going to ask that you doubt your senses. You doubt what you see. You doubt what you hear. You doubt your common. And that opinion will be in contradiction to the agents who investigated this case. So again, keep that in the back of your mind as you hold the state of Ohio to its burden of proof. Now, the court is going to give you some rules and guidelines in the jury instructions of how you are to analyze this. You will come to know of 3 factors called the Graham factors. They come from a case, Supreme Court of the United States case, called Graham versus Connor. These 3 factors must be analyzed in every courtroom by every jury here in the United States of America. That is what the Supreme Court of the United States has said. Now, the other rule that you've already heard several times by this point, and the judge will instruct you, is that you are not to judge this with 20/20 hindsight. But I'd like to discuss those Graham factors with you, as you will come to learn them. Number 1 is the severity of the crime at issue. You will hear that driving into a police officer, no matter how slow, if it causes serious physical harm, you can still be charged with felonious assault on a police officer. You will hear that a theft plus fleeing plus some use of force could potentially be an aggravated robbery. You will hear that these 2 crimes are very severe. So we will prove to you by a feather more likely than not, that the severity of the crime, this factor, is present here. The second factor is whether or not the suspect posed an immediate threat to officers or to others of serious physical harm or death. That 3,500-pound deadly weapon hit Connor Grubb. There will be no question that that parking lot was full of people that day. We will have proven to you at the end of the trial, by a feather more, that she was an immediate threat of serious physical harm or death to both Connor, Sergeant Moynihan, and everybody else in that parking lot. The third factor is whether the suspect is resisting or actively evading arrest. You will hear no less than 10 times she was told, "Get out of the car." There will be no question that this factor is also present, and we will have proven that by a feather more than 50%. All of the rules that the court is going to set out for you in these jury instructions that you must follow while you're deliberating. All of these rules will show you, the evidence will show you that on August 24th, 2023, Connor had the right to defend himself because he believed he was going to be seriously hurt. And because that belief is reasonable. Kevin Davis will tell you why Connor Grubb took the action that every reasonable police officer would do. He will tell you why he did what he did. Connor did not set out to hurt somebody, to intentionally hurt somebody on August 24th, 2023. He went to that Kroger because he was doing his job. He was doing his job when he was assisting with a lockout. He was doing his job when he was assisting the Kroger employee in attempting to investigate a theft. He was doing his job when he was covering his partner. He was doing his job when he made sure everybody else in that Kroger parking lot was safe. He was doing his job when he was run down and hit by a 3,500-pound deadly weapon. And an immediate threat like that 3,500-pound deadly weapon, an immediate threat to the officer or to others of serious physical harm, a broken back, a broken hip, a skull fracture, or death will permit him to respond with deadly force. At the end of the trial, my law partner, Mr. Collins, will come before you and ask that you find what the evidence demands in this case. And that will be that Connor Grubb had the right to defend himself against a 3,500-pound deadly weapon on August 24th, 2023. He will ask that you find Connor not guilty of all of the crimes charged. I thank you for your time.
Ladies and gentlemen of the jury, we're going to take our lunch break now. Is the bus coming at 1:30? You'll need to be back here at 1:15. And do not discuss this case among yourselves. Do not permit anyone to discuss it with you or in your presence. It is your duty not to form or express an opinion on the case until it is finally submitted to you. We'll be back about 1:15.
All rise.
So slow.
I got it.
That's what I heard.
Once or twice.
Everybody can have a seat. When I see council back in.
Okay. Text us about tomorrow.
Okay.
Okay, you guys are all good, out of here, we come back at 1:15, let's just go to do a meeting, okay? So, you guys wanna answer any questions out there tonight? Good? You're done for the day, you're done for the day. One more.
Okay, thank you. Yes, 3B. I couldn't remember.
Well, because they've been switching.
Yeah. Yeah. I just was getting out of the way. Yeah.
Yeah, I think they said they were going to be done.
They didn't say anything about orders.
Well, they told us testimony was going to start Monday.
I didn't see it.
I expected a lot more officers forward. Not room for them anyway. There's quite a reality in there when I showed up. Young man hit me in the corner. Anyway.
Let's move over. A few questions for you.
Okay.
Number one, are they gonna come up at 1:15 and then just load the bus and go to the jury view, or is there gonna be some sort of?
Yeah, we're going on the record. He goes the instruction for the jury, yeah.
Okay, and now, can we come along on the jury view? We have in the past, we've literally only gotten shots of the bus and
I
not
don't
even
give
the.
permission for, I
So-
mean, it's,
And who would that come from? Be the judge?
I mean, well, no, I mean, it's a public road.
Okay, so we're
So
okay.
we're good then, I guess?